Go home and maybe charge my computer.
Right, I'm
Maybe
live.
get
I'm live.
closer.
I'm not doing this again. I'm sorry. I don't know where I left off. Stop. I'm sorry. Warranties of title. Yeah, I know I was talking about warranties of title and the present covenants. So we'll just start at the beginning of warranties of title. The covenant of cession. The grantor warrants that he owns the estate that he purports to convey. A covenant of right to convey. The grantor warrants that he has instances this covenant serves the same purpose as the covenant of cession, but it is possible for a person who has cession not to have a right to convey. For example, a trustee may have legal title but be forbidden by the trust instrument to convey it. So right to convey, covenant of cession, covenant of right to convey, a covenant against encumbrances, a covenant of general warranty, a covenant of quiet enjoyment, a covenant of further insurances. And I get that's 6. I believe there's 7. So for the covenant against encumbrances, the grantor warrants that there are no encumbrances. Of the property. Encumbrances include that there are, among other items, mortgages, liens, easements, and covenants. A covenant of general warranty. The grantor warrants that he will defend against lawful claims and will compensate the grantee for any loss that the grantee will sustain by assertion of superior title. And that would be a future assurance or a future covenant rather than a present covenant, because the grantor is promising to act beyond the period when the contract has ceased to operate, like has been executed and fulfilled, I guess is what I mean. And then covenant of quiet enjoyment, this too is a future covenant. And then the grantor warrants that the grantee will not be disturbed in possession and enjoyment of the property by assertion of superior title, often merged into covenant of general warranty. And a covenant of further insurances, grantor promises that he will execute any other docs required to perfect the title conveyed. So these are your warranties of title. I do believe there's a total of 7, and I'm only seeing 6 here. But covenant of cession. Did you make one for me?
Yes.
Yeah.
Use your straw at your own.
I have it in for me. Right to convey. It won't go to the bottom if you put it in there now. 3. I'm still recording it, so I want to just write down these in my notes. But without everything, it seems to me that covenants of cession, right to convey, and against encumbrances, those first 3 are probably present. Page 6 of the outline for the definitions. And then the last 3, the covenant of general warranty and quiet enjoyment and further assurances. Those are all future. So I believe they're referred to as future, but on the next page we start talking about present. So present covenants, broken if ever at the time the deed is delivered, i.e. the grantor either owns the property or not. The statute of limitations begins to run at the time of delivery of deed. Future covenant, run with the land to all successors in the interest of the grantee, can bring a cause of action. Present covenants have no similar treatment. So that's the difference between the future and present covenants. Future covenants run with the land to all successors in interest of the grantee and who may bring a cause of action. And the present covenants, broken if ever at the time the deed is delivered. Broken if ever at time deed is delivered. All right, now, jurisdictional extension of warranties to remote grantees. The majority of jurisdictions hold that a remote grantee cannot sue a remote grantor, but the minority allow it. And the case cited here is Rockefeller versus Gray. And actually, seeing as I remember that case pretty well, let's see if I can find it, because I guess before official bar prep started, I was briefing my cases, but I don't know where my real property notes are, so never mind. Innocent misrepresentation. This is a misrepresentation of material fact made for remote grantee cannot sue remote grantor in majority. So I'll just write majority up here. Grantor. All right, so moving on to innocent misrepresentation, which just seems like it's in an odd place here because there's no other misrepresentation theories. There's just innocent misrep. And the factors, I think, is a representation of material fact made for the purpose of inducing the purchase. The representation is untrue. There's justifiable reliance by the plaintiff on the representation by the defendant and damages. So it involves a material fact. It's purposefully to induce sale. It's untrue, which I think sometimes requires knowledge. Element that you know it's untrue. And then there's justifiable reliance on the representation, and there's damages. So that's 1, 2, 3, 4, 5 elements. Recording. So like we go to a completely different site. Like that was just such a detour. Recording. Deed recording is not required to give deed a legal effect, but is advised. Sometimes referred to, I think, as attestation. This is my outline of Applebaum's class. Yeah. Required contents. To give deed effect to transfer and also requires delivery. Instrument in writing, delivery, name of grantor, name of grantee, which there's split jurisdictional rules on the name of the grantee, the address or a description of the property conveyed, conflicting description issues, plat, parcel map, my house in San Francisco if there's only one, words of grant. These are all components of the deed. The words of grant in California, statutory grant deed uses one word, grant. The signature of the grantor and the notarization attestation required for recording, but not required for transfer between grantor and grantee. We'll go to the gym after this. So the deed is still valid even if it's not recorded, but it must contain, well, it must be in writing, and it must involve delivery. And then you've got the parties, at least the grantor. You've got a description, words of grant. Now, in signature of the grantor, at a minimum, just the grantor. And notarization / recording is kind of optional. Seal. A deed is a sealed instrument. Seal is required for conveyance of freehold. Forged seals are void, and grantor whose signature was forged prevails over all subsequent purchasers under principle that loss transferred to innocent party who could have prevented loss. Fraud, however, is the opposite. So I'm just putting quotes here where it says notarization recording. Like I'm just writing under seal. McCoy versus Love is a case where the deed was conveyed less than interest than bargained for, which is less interest than bargained for, which is equivalent of fraud. Other cases, coercive. Sheffield versus Andrews constitutes a forgery. I should better brief those cases, but they're here for the case name. Indentured servant. Historically, 2 copies were made and cut to show edges match up for genuineness. So that is very true. Documentary stamp tax. State documented stamp tax. Deed poll. U.S. Recording Office distributed copies. So I'm just writing down some interesting terminology that was in the book. Of a headache. Boundary disputes. Estoppel by deed. If grantor conveys land to a grantee that he doesn't own and warranted title to the land, then if he later obtains title, he is compelled to pass the title to the grantee automatically without necessity of lawsuit. Consideration. Bona fide purchaser. Oh my God, I feel so sick now. I'm going to go until we get to the next section, which is financing real estate transactions. So we're talking about estoppel by deed. If grantor conveys land to grantee that he doesn't own and warranted title to the land, then he later obtains title, he is compelled to pass the title to the grantee automatically without necessity of lawsuit. Okay, I remember now what that is. It's on page 611 of the book. Consideration. Bona fide purchaser, some terms here that matter. Delivery, dash grantor to deed to third-party escrow agent who gives the deed to the grantee. So I've got a little bit of a sequence here. In such a case, death of the grantor, the escrow agent, who must convey an equity, even if the grantor dies before the conveyance to the deed to the grantee. Delivery, an act that evinces an intent to be immediately bound by the transfer. So like by delivering to your third-party agent, you're meeting the requirement of delivery and you have a contract, even if the grantor dies. In fact, you have caveat emptor. No. You have I don't remember. Writing down the definition of delivery is an act that evinces an intent to be immediately bound by the transfer. So that in the death that this is operable, if you just held onto a deed in your safe, intending it to pass on death, then you are failing to meet the requirement of delivery, and on death, that would not be an effective way of transferring property. So, delivery without handing over, and you have within this section, donative transfers. Inter vivos transfers of land requires delivery of signed instrument. Transfer at death must comport to statute of wills or by declaration of trust. See Rosengrant versus Rosengrant. It is established law that when the owner of land executes a deed during his lifetime and delivers the same to a third party who acts as a depositary rather than an agent of the property owner, with instructions to deliver the deed to the grantee with herein named upon his death, intending at the time of delivery to forever part with the lawful right and power to retake or repossess the land, or to therefore control the same, the delivery to a third party thus made is sufficient to operate as a valid conveyance of real estate. A deed complete on its face and authenticated, but with an oral condition, get the property when I die. If the deed is recorded before they die in the prevention of fraud, the oral condition is not given effect. If the condition was written, if I do not return from war, then it would be given effect. So these are all the stipulations around the element of delivery. Legal delivery is not just a symbolic gesture. It necessarily carries all the rights and consequences of absolute outright ownership at the time of delivery, or it is no delivery at all. So I'm just adding that to my definition. Symbolic gesture necessarily carries all rights and consequences of absolute outright ownership. Okay. Valid presenti conveyance requires. That's Latin. I like posting Latin in my Twitter account.
That was pretty interesting.
I know. Can you see here? Actual or constructive delivery of the deed to the grantee or to a third party, and intention by the grantor to divest himself of the conveyed interest. So let's look at presenti. It means at the present time. By words, per verba di presenti, by words of the present tense. So at the present time. Paste. Okay. Oh, I'm already here. Actual or constructive delivery of the deed to the grantee or to a third party, and intention by the grantor to divest himself of the conveyed interest. So that's kind of what valid presentee conveyance requires. It requires actual or constructive delivery of the deed to the grantee or to a third party and an intent. So delivery plus intent is intent to convey, right? Not really like components of a deed that you have these other concurrent acts, but it is required for a deed to be valid. Intention by the grantor to divest himself of the conveyed interest. So I'm not going to keep on going, I don't think, even though I only went like one page and I probably already read it. The next section is financing real estate transactions, and then consumer protection laws, and the mortgage crisis and the Great Recession, and mortgage substitutes before getting a title assurance. Should I try to get through that? Okay. Intro to mortgages and mortgage markets. Some of this is just historical. Geographically limited to SNL, Savings and Loan Corps, for example, supply and demand affected interest rate. Another note, secondary mortgage market to even credit flows across the nation. That's how that developed. GSEs, the government service entities, address S and D, which is supply and demand, and naming a few, Fannie Mae, FNMA, on bonds, and as a bond issuer in 1938 was created to offer mortgage-backed securities for investment. Freddie Mac, FHLMC, which is a Federal Home Loan Mortgage Corp, was established in 1970, offering mortgage-backed securities for investment, fully amortizing fixed-rate mortgage, and ARMs were created in 1980s, and the subprime alt A market of lower credit score, the no-doc loans, 100% financing, and negative amortization is kind of the last part of this historical section. Promissory note, mortgage between mortgager, mortgage holder, and mortgagee, who is the lender. And a mortgage is an agreement to give a lender an interest in real property as security for debt. You have a mortgagor, mortgagee, and a purchase money mortgage. A mortgagor, borrower who gives the promissory note and pledges real property as security for a debt. Mortgagee, the lender who receives the security interest in real property as security for a debt. Purchase money mortgage, security interest in real property purchased with money advanced by the lender. Deed of trust is a three-part instrument in which borrower transfers title to third party who holds it as trustee for the lender. Arrangement solely for foreclosure simplicity. Trustor, borrower, beneficiary, lender, and trustee of the party who holds title. So a deed of trust happens in California, which makes it hard for me to adjust. But again, it's a three-part instrument in which the borrower transfers the title to a third party who holds it as a trustee for the lender, and it is solely arranged for the simplicity of conducting foreclosures. The parties involved is your trustor, who's the borrower, your trustee, who's the third party holding it, and the beneficiary is the lender. Mortgages, land as collateral for a debt. Theory of title is really important. So in the lien theory, the mortgagee holds a security interest only. In the title theory, the mortgagee holds title until the mortgage is satisfied, which lends to, in effect, in title theory states, the issuance of a mortgage to a joint tenant will sever a joint tenancy because title has been affected. Whereas in the lien theory, does not affect the joint tenant ownership structure for a mortgage to be issued to one of the joint tenants. There's an intermediate theory where the mortgagee holds title only after default. If the mortgager transfers the mortgage land, the grantee may agree to assume the mortgage and become primarily liable to pay the mortgage loan. This is usually restricted in promissory notes terms. And then a grantee who does not assume the mortgage is not personally liable for the loan, but may lose the land if the transferor defaults. Equity equal. I feel like realistically that never happens, but they do question it. And a lot, actually. So a grantee may assume the mortgage and become primarily liable. A grantee also, theoretically, generally this is never the case, it gets paid off. But in the second alternative, the grantee who does not assume the mortgage is not personally liable for the loan, but may lose the land if the transferor defaults. So this explains why, if it's not assumed in an NBE question, if the mortgage is not assumed by the grantee in an NBE question, and the question says somebody defaulted, or a successor in interest, or somebody, who can they recover from is the question. You will tell them the seller, the grantor in that transaction. So, equity equals fair market value minus debt. If equity is negative, then the borrower is underwater. Equity of redemption history. Chancellors protect money lender with terms. Mortgager gave mortgagee fee simple subject to conditions subsequent to real property. Thereby, deed held by money lender was void the day of repayment and valid. And default constituted ownership in the money lender, offering mortgager right of redemption shortly thereafter upon Chancellor's rules, which was called foreclosure. Okay, I know what this means. I don't know if that made any sense. But right of redemption, what it means. Okay, let's just read this. Deed held by money lender. Okay, so the mortgager gave the mortgagee a fee simple title, obviously, in Old England, and the deed was held by the lender. In default by the mortgager constituted ownership in the money lender, but the mortgager had a right of redemption like the next day or something. I don't know. They had to pay everything off the next day to own the house. And that was how foreclosure worked. Strict foreclosure, it says demand / order to pay or forever barred. Foreclosure sale, judicial process by which court supervises sale of mortgaged real property to satisfy debt. Non-judicial foreclosure is tax sales mechanics lien, and originally it was an action in the court of equity to foreclose, cut off the equity of redemption that courts in equity had created. Which again, I think goes back to the right of redemption. I think the right of, I don't know, it's a little bit hard for me to interpret if this is the same right of redemption that would mean that a mortgage or doesn't take title until the day after their mortgage is paid off in Old England, that is. And maybe that's the right of redemption, is like the next day or something, it's yours. But here it's being all entwined with foreclosure, as like offering the right of redemption in court of equity. So what I've crossed out here is judicial foreclosure required right to redeem from the lender to recover judgment for deficiency against mortgager. I get too hung up on this because it's a history section. Deficiency judgment, this matters. Judgment awarding mortgagee, beneficiary, the difference between the sale price at disclosure or private sale, and the total amount of debt. I think this is meant to be foreclosure. So the difference, and there is some responsibility on the mortgagee to get the best price so that there is a deficiency judgment to deliver to the mortgage or borrower protection, mostly statutory, varies by jurisdiction, many enacted in time of depression or recession due to falling land values. Fair market value limitation. Mortgagee can get a deficiency judgment only if sale price meets judicially determined fair price or fair market value. Anti-deficiency legislation prohibits a mortgagee from obtaining deficiency judgment under some circumstances, i.e. subject to the statutory right of redemption, which here, I think present day, allows the mortgagor to redeem the property after the foreclosure from the purchaser at foreclosure sale. Yeah, that's how it's interpreted today. Is that statutorily there's a way, there's some jurisdictions that will be like for 90 days, this person can redeem their house that was lost in foreclosure if they pay like value to the purchaser. The mortgagor may redeem the land by paying the amount due. Borrower protection in California, one action rule. If the mortgagee sues the borrower before exercising the right to foreclose, the right to foreclose is lost. This is like very important. So I just wrote one action in California. If the mortgagee, the lender, sues the borrower before exercising the right to foreclose, the right to foreclose is lost. Lender must first exhaust security before seeking deficiency judgment. In other words, I think that's what that means. In other words, anti-deficiency legislation. No deficiency judgment after non-judicial foreclosure, which is a private sale. And then vendor cannot recover in any case. The third-party lender cannot recover if the loan is to purchase borrower occupied dwelling for 1 to 4 family dwelling. That's all written under the anti-deficiency legislation. Statutory right to redeem only after judicial foreclosure. This might all have, this probably all pertains to California. And so does the deed of trust, which is the next section. So let me get this right, I think. Anti-deficiency legislation 1, 2, and 3. 1, no deficiency judgment after non-judicial private sale. So non-judicial foreclosure, which is a private sale. There's no deficiency judgment. And by deficiency judgment, we mean, I think it's the same terminology, but it depends whether there's a surplus at sale or a deficiency. But if it's a private sale, you're not getting any deficiency whatsoever. Probably in California, Section 580. Vendor cannot recover in any case. And the third-party lender cannot recover if the loan is to purchase a borrower-occupied dwelling, 1 to 4 single-family home, right? So the third-party lender, she don't really know what is a third-party lender. I'm guessing this is like a subordinate lender, a subordinate lien holder. I'm just going to substitute third-party lender for subordinate lien holder, ? And when you say it that way, cannot recover if the loan is to purchase, if it involves a single family, like a 1 to 4 family dwelling, purchase money loan. If a purchase money loan I'll just say involves I think that's what I'm trying to say in this anti-deficiency legislation. It's kind of off topic. Statutory right to redeem, except for me, except for this person right here. Statutory right to redeem only after judicial foreclosure. No right to redemption after non-judicial foreclosure, and only if deficiency judgment was entered. And you have another California citation, section 729.010. Period of redemption, 3 months after the date of sale, if the proceeds of the sale are sufficient to satisfy secured indebtedness with interest and cost of action and of sale. That's your period to exercise your right of redemption. And then 1 year after a date of sale, if the proceeds of the sale are not sufficient to satisfy secured indebtedness with interest and cost of action of a sale. And in conclusion, I just always think of it the Brady Bunch. Did you ever see like the Brady Bunch movie where like all of them are trying to like, I don't know, like do their whole like show and win like talent prize money to like save the house or something, and like they're all running a house where there's like a foreclosure. They were like running in a house to give the money to the bank who's standing there next to like obviously some person who's executing a foreclosure. And then I always think of it when I read through this. So it's the Brady Bunch. I mean, that's how they became a band, I think. Cindy got the band together. So I'm moving right on to the deed of trust, I think. No, okay. In conclusion, a mortgagee must foreclose on deed of trust through action by trustee. It's the only way to obtain a deficiency judgment in California. Like, that's the long story short, is that deeds of trust live here. I don't know where else they are in the world, but that's how it works here. If mortgagee forecloses in non-judicial action, there is no deficiency judgment available. So, okay, so alternatively, they can do it another way, but they're not getting able to pursue the mortgagor, the person obligated to pay the loan for any amount that is still owed the lender after the foreclosure is conducted and the property is purchased for an amount that's less than the loan payable. So, deed of trust is next. Under deed of trust, the buyer conveys title to the land to a person who is usually a third person, but maybe the lender, to hold in trust to secure payment of the debt to the lender. And this is recognized in most jurisdictions, which I don't agree it is, but I'll take it. It is here in California, but similar to a mortgage, but a third-party trustee conducts foreclosure. Oh, I'm sorry. It's developed in order for the mortgagee to recover the land sooner, like after default, and not have to jump through 15 hoops like in every other state, like Delaware, New York, Pennsylvania. Trustee can foreclose on default. Right? Because they're the title holder for that period. Or the title's being held in trust for the mortgage company, and if a default occurs, that is the act that allows them to foreclose. They don't, and it expedites the process. Mortgage, not a deed of trust, may also have power of sale subject to procedural safeguards. Acceleration clause activates foreclosure. So from being 3 months overdue, you end up being obligated to pay the entire amount. And the acceleration clause applies. And the power of sale clause, a clause in the mortgage deed or deed of trust agreement giving the mortgagee, the trustee, the right to sell the property at a private sale upon the mortgagor or trustor's default rather than go through judicial foreclosure process. And for superior liens and subordinate liens, foreclosure After default, the property may be sold to satisfy the debt. It does not affect senior interests, and it terminates junior interests. Junior interests are entitled to any surplus remaining after the foreclosing property is satisfied. So this is so important to the MBE because all they do is ask where the money goes after a sale, and they give you the whole history. The point being that a foreclosure by a junior lien holder does not affect senior interests. What does that mean? I think that means that when you buy a property at foreclosure, at least in this artificial legal sense, if you would have foreclosure buy a house, you are also assuming the senior mortgage, like the what did I call it before? You're
Probably have a chance to refinance.
Yeah, but yes, everyone always has that. Subordinate? I said subordinate leader. I forget who. So the superior. I wrote superior, but really, and subordinate liens, but it's not superior. It the word for, let's just call them senior interest, right? So the person at foreclosure buys the house. They assume the first mortgage, the purchase money mortgage, or mortgages that were recorded first, even before the purchase money mortgage. I learned this recently. Any junior interests will actually be assuming the junior interest too if they didn't have notice of the foreclosure. But if they did have notice of the foreclosure and there is insufficient funds to pay off the junior interest will not become the purchaser's obligation.
That's unsecured debt.
Basically. Well, it's still secured, but it's kind of, what's the word, exonerated.
It's kind of low priority.
Yeah, low priority. It is in the priority order in this. It's going to just, and it's a higher risk, which generally bears like a higher interest rate. And so to cover for this potential outcome. So when you are asking the bank for like a second, they know that it's like more risky than your purchase money mortgage, which is superior to their mortgage. They sign a subordination agreement and everything if they're going to refi or something. But anyway, deficiency judgment. Can bank recover balance from a borrower if the foreclosure sales leaves them deficient? Preference for public sale based on scrutiny whether sale price was fair. In other words, if there is a deficiency, the mortgagee can sue mortgagor if the foreclosure sale proceeds do not satisfy the mortgage debt. Anti-deficiency statutes leaves no deficiency judgment available. Duty, fiduciary, trustee, good faith, and due diligence. Tort for wrongful disclosure, and these are all just things under the anti-deficiency statutes to be aware of. And for example, mortgage foreclosures on page 623 included the case of Murphy versus FinDev Corp, which involved, chilled bidding and defective foreclosure. And another case, many pages later, the consumer protection laws here, preemption, depository institutions deregulation and monetary control act of 1982, and the Garn and Saint Germain depository institutions act of 1982 preempt state inferences with enforcement of due on sale clauses. That was before my time. And then FHA, the Fair Housing Act, enacted in 1968. The Community Reinvestment Act I have here was enacted sometime in the 70s. HMDA, 1975, which is the Home Mortgage Disclosure Act. FIFA and HUD, which is Fair Housing Finance Agency, and Housing Urban Development. And I have a little arrow to Fannie Mae and Freddie Mac, which we discussed before. I think perhaps enacted under the Federal Housing Enterprises Financial maybe Safety and Soundness Act of 1992. I don't really know if they had anything. No, they don't have anything. Whatever. Safe Act to curb equity stripping. You know what the Safe Act is, which is oh my god, safeguarding and I don't remember anymore. Basically requires that like lenders are part of it, are trained in part of a registry that allows consumers to really bring complaints against them, so that it eliminates loan sharks from abusive lending practices. Reg Z to address fee pyramiding. RESPA Section 8 does that too. So Reg Z, Truth in Lending Act, RESPA, Real Estate Settlement Procedures Act, Section 8 also achieves the same. HOEPA is the homeowner. Okay, how this differs from HOPA. HOEPA, I forget. Of 1994 and the Dodd-Frank Act of 2008. Most equitable defenses are unavailable to homeowners as a result of holder in due course doctrine with secondary mortgage market, and the lender sells and assigns the mortgage or the legal risk. Due course doctrine. Okay, so foreclosure alternatives is your deed in lieu and short sale. So I know all about that. So deed in lieu of foreclosure, you just give the keys to the bank and let them let you walk away rather than going through a whole foreclosure. And then a short sale is when you're selling your house, even though it's but the bank has to approve the sale of it because you're delinquent. And then, oh my god, what's this? Hey Siri, what is the HOEPA?
Here's what I found from
Homeownership and Equity
acronymfinder.com.
Protection
HOPA
Act.
stands for
I knew
homeownership.
that. Okay. The mortgage crisis and the Great Recession. Case number Commonwealth versus Fremont Investment and Loan U.S. Bank National Association versus Ibanez. A title and I didn't brief it, but title theory state lender deemed to have legal title to real property. In other words, the mortgagee holds title until mortgage is satisfied. Lien theory state, a mortgagee holds a security interest only. Standing issues. Borrower can't object to an assignment. Can holder of mortgage note bring foreclosure? Robo-signing, Foreclosure Act. Good faith efforts to inform of loss mitigation options by day 36, 120 days before property can go to foreclosure. No dual tracking, meaning the bank can't pursue loss mitigation options at the same time as a foreclosure. If a borrower has elected to apply for a loss mitigation option, then foreclosure has to be brought to a halt until that process, until that borrower is denied. And the loss mitigation application has to be, I guess, sent at 45 days. A SPOC, which is a single point of contact, has to be assigned to the mortgage. Homeownership counseling disclosures need to be given with all of these materials. And then TARP is a Obama administration sort of relief program. What does TARP stand for again? Troubled Asset Restructure Program? I don't know. Hey Siri, what does TARP stand for?
TARP is informal term it means.
No. Hey Siri, what is the acronym TARP from Obama's TARP funds program stand for?
Okay. I found
Troubled
this on the web
Assets
for acronym
Relief
TARP
Program. I don't know if that's what it said. Yeah, troubled assets relief. Moratoria. CFPB.
Might come in handy again after 2000.
And if there's still funds in it, yes. But they already like have a different program or something. CFPB was built after this mortgage crisis. It assumed the OTS. No, the OTS was the Office of Thrift Supervision was assumed by the Office of the Comptroller of the Currency, and MERS, Mortgage Electronic Registration Services. MERS is a nominee, and the lender is the beneficiary. Purpose is to simply securitization and mortgage reassignment, or simplify. I'll probably say simplify, and this is involving secondary market sales. And I just wrote here stamped a lot. The fact is that the lenders were all selling their portfolios to other lenders so that they could all be triaged and security for in the bond market in
Say tranched or triage?
tranche. And so what they did is they used MERS as like a central registry to hold the mortgages and the notes, but probably mainly just the mortgages, in with MERS, so that they wouldn't get lost track of, because you can't foreclose if you don't have a mortgage, technically, which is one of the biggest infractions of the mortgage crisis and Great Recession, and kind of part of what was termed robo-signing, without actually having mortgage in hand. And so some of these mortgages, so MERS is frequently used in the market for just kind of being a custodian, practically. It says here they're a nominee, but it's kind of like a custodian for all the mortgages in the world or in the country. Mortgage substitutes: an installment land contract, aka a contract for deed. A possession is taken, a contract to convey title at a later time after installment payment to balloon as is, no warranty, covenants, forfeiture at default. Judicial approach number 1 is to treat it as a mortgage. Number 2 is to treat it as a mortgage, sometimes pertinent to factors, i.e. equity. And the third approach is the property is taken back, purchaser rejected, reimbursed to purchaser the down payment if it exceeds damages, and then rent, lease to own, option fee up front, option at end of term to purchase all, repairs to code on purchaser. So that's it for the mortgage financing section. The next section is title assurance.